The Honorable Arkansas Court of Appeals is now in session. All persons having business before this honorable court, give attention, draw near, and you shall be heard. May God save these United States, the state of Arkansas, and this honorable court.
Thank you. Good morning. Today, our court announces the disposition of 24 appeals. Information about these appeals are available on the judiciary website. We have one oral argument this morning. It's case number CR-20-193, Barnum versus the state of Arkansas. Counsel, we will let you know this is the first time that the Court of Appeals has done a Zoom oral argument. So bear with us if we talk over one another. We have quite a bit of experience with Zoom conferences, so I think we'll be okay. Another thing I want to note, I see Mr. Jackson, you're already standing. I know that you all received notice that you should stand when you address the court. This panel has determined that if you're more comfortable in your office to stay seated, you can. We don't care one way or the other, just so long as we can see you when you're speaking. I can't guarantee you that every panel will do that, but this panel will give you that option. All right, Mr. Kaiser, I understand you want to reserve 5 minutes for rebuttal?
Yes, Your Honor.
All right. Are you ready to proceed?
Yes, Your Honor.
Mr. Jackson, are you ready to proceed?
Yes, Your Honor.
All right. Mr. Kaiser, you may make your argument.
Thank you, sir, and may it please the court. In the 2007 comedy film Anchorman, one of the news anchors famously commented on the effectiveness of a particular product that 60% of the time, it works every time. Audiences and myself laughed because a statement like that is comedic. It is nonsensical, it is illogical, it is pure fallacy. The statement itself defeats the very purpose of using numerical percentages for probability in the first place. Such comedy, such comedic logic has no place in a court of law. However, this is precisely the type of expert testimony that the state adduced in this case. Dr. Rachel Klingenpeel testified that in 95% of actual sexual assault cases, there are no physical injuries, and that there were no physical injuries in this particular case, making it consistent with 95% of all actual sexual assaults. The jury was informed that the absence of physical evidence in this case meant
All right, counsel, Ms. Pechtel, Mr. Holtoff, Mr. Kaiser has frozen up, at least on my. I have no audio, and he is frozen on his video.
Judge Gladwin, this is your
Yes,
clerk. He is frozen on my screen as well. I will see if I can get him to leave the argument and come back. If you'll give us just a moment.
Okay.
Okay, thank you.
Makes you almost want to risk infection just so that we can do this the right way.
Almost.
Almost. All right, Mr. Kaiser appears to be moving again. Can you hear us, Mr. Kaiser?
Yes, I don't know what happened. I'm sorry, Your Honor.
All right. All right, you can continue on with your argument. Thank you.
And thus the implication that the alleged victim in this case was telling the truth accordingly. This is precisely the type of testimony that Arkansas appellate courts, including this court, have long found to be improper because they, one, invade the province of the jury in determining the credibility of a witness, and two, are irrelevant. Just as in Buford v. State, 368 Arc 87, a 2006 case from the Arkansas Supreme Court, which I cited in my 5-1J notice, the lay jurors in this case were fully competent to determine whether the alleged victim was telling the truth. There is no doubt that the elicited testimony invaded the province of the jury because the type of testimony at issue is not the kind that is beyond the ability of the trier of fact to understand.
Mr. Kaiser, let me ask you a question. Is the jury not able to determine the credibility of the doctor, of whether she, with her percentage of 95% of the cases have no injury? Is that not a fact question, essentially? Although it's not a fact that is relevant as to whether the rape occurred or not. Can they not judge that credibility also?
Your Honor, I think that would be relevant. It's the problem that Dr. Klingenpeel went the one step further in saying that the lack of physical findings in this case was consistent with the 95% of actual sexual assault cases. So we have two cases cited by the state in their appellee's brief, the Pafford case and the Keck case from the Arkansas, well, Pafford from this court, Keck from...
Hang on, Mr. Kaiser. Why is that even important? Your client admitted that there were sexual relations between he and the victim. Why do we even care whether there's injuries or not if he's admitted that, yes, we had sex, but there was no forcible compulsion?
Your Honor, because one of the factors that this court and the Arkansas Supreme Court looks to, although it's not required, is whether or not there was physical force and if there circumstantial evidence of that force as shown by physical injuries. And several of the cases cited by the state have that present, which we just don't have here. Essentially, the state was allowed to say that the absence of evidence in this case was evidence of my client's guilt. That's the problem. We have no problem with a doctor testifying that in the vast majority of sexual assault cases, there are no physical findings consistent with sexual abuse. It's the step further that she took in this case past what this court and the Arkansas Supreme Court said was permissible in the Pafford and Keck cases. In Keck, for example, the expert did not give a diagnosis of rape, nor did he testify the child was telling the truth. Rather, in his testimony, he stated the lack of physical findings did not discredit her history. The difference between that case and this case is immense. Here, rather than saying it did not negate the alleged victim's story, it was implicitly used to confirm her veracity and to state that it was consistent with an actual sexual assault victim. That's where the distinguishing feature between permissible testimony from this type of expert and the line between what Dr. Klingenpeel did here is. Similarly, this court in Hall v. State, 1985 case, reversed and remanded based on erroneous admission of a sexual assault expert's testimony about the dynamics of child sex abuse cases generally. And that's exactly what happened in this case. This court in Hall found the evidence was not admissible because it tended to cause the jury to decide the case on the basis of how most people react to rape or on whether the reactions of the victim were the typical reactions of a rape victim, when the jury's obligation was to decide whether the elements of the crime had been proved in the case at hand. And that's exactly the same issue that we have in this case. I cited some out-of-state case law, Chappell v. State from the South Carolina Court of Appeals last year, noting that a comment on the credibility of a class of persons to which the victim belongs is a comment on the credibility of the victim. And that's exactly what happened in this case. The unfair prejudice from the erroneous admission of this evidence was massive, as the state was permitted to argue that the absence of physical evidence actually supported the alleged victim's claims of sexual assault. This subverted the state's burden entirely, and as stated previously, improperly invaded the province of the jury to determine JG's credibility. And I'll just quote from Dr. Klingenpeel in her testimony. She stated, in the vast majority of cases of child sexual abuse, there are not any physical findings that are diagnostic of trauma. There are 4 reasons why that is the case. And she lists several medical reasons why the female anatomy is resilient and why it may not leave physical findings of sexual assault. But she leaves out the 5th potential reason, which is that a sexual assault did not occur. And that's the problem with this testimony in general. This is precisely the type of generic sexual assault victim evidence that is not permitted. Later on, in response to a prosecutor's question, is it possible for a rape to occur or a sexual assault to occur and not cause any physical injury whatsoever? And again, appellant has no problem with that question. But the response, it is not only possible, it is normal. Again, that's fine, but here's the problem: normal and expected. And then she went on to testify that the findings, lack thereof, in this case, were consistent with those 95% of actual sexual assault victims. While Klingenpeel did not go all the way and testify that JG was in fact telling the truth, there can be no doubt that was the strong implication left in the jury's mind. That JG's lack of physical injuries was consistent with the vast majority of actual sexual assault victims, and thus that she was telling the truth, just like the children in those 95% of cases where there were no physical findings. The problem here is that Klingenpeel was permitted to compare the alleged victim in this case to the prototypical victim of an actual sexual assault. This evidence is admissible because it invades the province of the jury, who is not asked to determine whether the charged act fit the pattern or archetype of sexual abuse, but whether sexual abuse occurred in the first place.
Why is that not a subject that is subject to vigorous cross-examination, like any expert witness? It would seem like you want to attack the credibility of the study, or the 95% or the 80%. That seems like it should go to the weight as opposed to the admissibility.
And I appreciate that question, Your Honor. And trial counsel in this case did cross-examine the expert regarding these figures. The problem is, again, our issue is not with the admissibility of the figures, which I agree would be ripe for cross-examination. It's what she did with those figures in stating that the alleged victim in this case was consistent with 95% of actual sexual assault cases. That is our issue. Moving on to the point regarding sufficiency of the evidence, I just want to be clear that the appellant is not arguing that an alleged victim must physically fight off the defendant's advances in order for there to be forcible compulsion as convicted in this case, nor are we arguing that there must be physical findings of damage to the victim's body or genitals. Just that these are 2 of many potential factors identified in the case law, none of which were present in this case. There were no physical injuries to the victim. There was no alleged use of a weapon by the defendant. There was no alleged threats to kill or harm the victim or anyone else by the defendant. There is no evidence of the victim physically fighting against the defendant during the sexual encounter. There is no evidence of the defendant pulling the victim's hair. No evidence of the defendant threatening to discipline the victim if she did not engage in a sexual act. There's no evidence of the defendant subduing the victim or placing him or her in a headlock. There's no evidence.
Excuse me, where does the evidence come in where he's 31 years old and she's 14 years old? Is that relevant?
Is it relevant to whether there was forcible compulsion?
To your sufficiency argument?
In and of itself, no. The Arkansas Supreme Court has made clear that mere sexual contact with an underage person does not constitute force. And that was Myers v. State. Excuse me, that was this court. Myers v. State 2017 Arc App 617, rejecting a trial court's definition of force to include any sexual act involving a child. We're not here to say that that was a moral act or even a legal act. It likely would have fallen into a lesser sexual offense than rape by forcible compulsion. It just does not constitute rape by forcible compulsion.
Well, in Canard versus State 278, Arkansas 372, the Supreme Court concluded the fact that she said she was raped, when considered with the age of the victim and the fact that the appellant is her father, leads us to conclude that there was sufficient evidence to conclude forcible compulsion. Sounds like to me the Supreme Court has used the factors of the age of the victim and the perpetrator and the relationship between the two.
Yes, Your Honor. Kennard predates the current criminal code. The victim in that case was 11, and the offender in that case was her father. So there is some distinction between an 11-year-old and a 14-year-old. As the court knows, the rape statute criminalizes any sex with someone under 14 as rape without need for forcible compulsion to be proved. Further, the Supreme Court in that case pointed heavily to the fact that the offender was the victim's father in showing that requisite force, and that's just not something that we have in this case. I believe that case is perfectly distinguishable. Here, there was no evidence that the alleged victim tried to get away or physically fought off Barnum's sexual overtures, as in the case of Holland v. State, which the state cited in its 5-1J notice. Indeed, all of the cases cited by the state in its brief are distinguishable in that they contain at least one of the factors I previously mentioned, whereas the case here does not. This case compares favorably to the Mills case cited in the appellant's brief, where the defendant threatened to harm one of the alleged victims after having sex with him and lured another victim into a sexual tryst under false pretenses. And his attempted rape and rape convictions were reversed and dismissed in that case. Here, there was no evidence presented that Barnum used any physical force or made any threats. There was no proof that her subjective feeling of fear was based on any actions by Barnum that could reasonably be interpreted to have engendered such fear. As JG testified at trial, she was scared, but also that she did not say anything and that she physically froze during the encounter. The state is essentially arguing that mere sexual contact with an underage person alone constitutes the requisite force, but as we've discussed previously, this court in Myers made clear that that cannot be so. At this time, Your Honors, I would reserve the remaining 1 minute and 50 seconds for rebuttal, along with my other 5 minutes. Thank you.
Thank you, Mr. Jackson.
Thank you, Your Honor. May it please the court. I am Assistant Attorney General Adam Jackson, and I represent the state in this matter. In all due respect to appellant's quotation from Anchorman, I have a quote for this court to consider. No, that's what JG said in this case. When appellant approached her as she was sleeping on her sister's couch in the middle of the night, he demanded sex and she said no. After she said no, he pulled her underwear down, got on top of her, putting his body weight on top of her, penetrated her, then flipped her over to ejaculate on her buttocks. That is rape. The act occurred after she said no. The important thing for this court to consider when it comes to physical force is what's been repeated by this court and the Supreme Court, and it's not a quantum, but it's whether the act was against the will of the victim. Here, she said no, and it happened anyway. Now, as Judge Hickson, as you pointed out, Kennard talks about this subject where the pants were pulled down and the victim called it rape, and that was enough for the court to consider it. Now, appellant's attempting to distinguish that case by saying it was under a previous version of the code. It doesn't matter that it was under a previous version of the code, whether it was 11 or 13. What was at issue there was forcible compulsion, and the charge was rape by forcible compulsion, and that's what is at issue here. That's what is at issue in the cases that the state has cited dealing with second-degree sexual abuse. It's the forcible compulsion element that this court is looking at, and repeatedly has said, is it against the victim's will? And if so, it's the forcible compulsion element is met. Now, turning to appellant's, really his his seventh argument is brief, but what he first argued here, and that's Dr. Klingenpill's testimony. As an initial matter, the objection isn't preserved. The objection below was a preemptive objection. Looking at the motion in limine, it was to prevent the experts from testifying that they believe the victim or bolstering the credibility that way. The circuit court below granted that motion in limine. So when it comes to the doctor's testimony, the doctor testified that JG's physical examination was normal, but that is the case for 95% of all pediatric sexual abuse patients we see. She's talking about this in the clinical sense of what she sees at Arkansas Children's Hospital as the head of the sexual assault response team. She's talking about patients that she sees coming into her clinic. It's not about testifying that all these patients are telling the truth. She's coming in and she's treating them, and her testimony is that 95% of all the patients that she sees don't have an injury. So when appellant objected to that below, the objection was, Your Honor, this is where we were at in our motion in limine. We're objecting to where they're going with this. I'm objecting to the opinion, this line of testimony about the percentages of assaults where there are no findings of physical trauma, and yet the doctor is going to say the assaults are in fact true. The state was quick to point out that this is not where the line of questioning was going, and the court below furthermore acknowledged and said that it understood appellant's objection was the state would not be permitted to ask if the findings meant JG was telling the truth. And it even agreed with the appellant that it would not allow the state to ask the doctor, if it was believable or were they telling the truth. The court below clearly understood this as a preemptive objection to prevent the state from asking, are they telling the truth? That's how it was characterized by the court as what it understood. And it even agreed and said, not going to allow the state to ask that, but to the extent what's already been said, is admissible, and we're moving on. So for them to now argue that really it was the 95% was what was inadmissible in and of itself, that's just simply not preserved. However, to the extent it is preserved, this really does go to what Keck and Pafford were getting at, that it doesn't bolster the credibility. The testimony is not bolstering the credibility of the victim. What the testimony is doing, as we said before, was it's just simply saying this is what we see in clinic. It's not testifying to the credibility of anybody they see in clinic, and it's not testifying to the credibility of the victim. The purpose of this testimony is really to rebut the defense, and the defense's argument is there was no injury, therefore there was no rape. So they're putting on this testimony by this doctor to say, just because there's no injury doesn't mean that nothing happened. That's leaving it up to the jury to decide at that point whether they believe the victim. It's just simply targeting the appellant's defense. And furthermore, even if this court were to view some kind of error in that, it's not to overturn absent prejudice. And the key fact in this is prior to Dr. Klingenpill's testimony, the sexual assault nurse, the same nurse, Bradley, testified that in the majority of cases, there's no findings. That came in without objection. So to the extent that the issue is about this percentages, it's just simply he can't show prejudice because this other testimony, which was cumulative of what the nurse said, or what the doctor said, came in without objection. Therefore, no prejudice. And Your Honors, unless this court has any questions from the state's comfortable in relying on its briefing as to all the remaining issues. and ask this court to affirm appellant's rape conviction and sentence. Thank you.
Thank you, Mr. Jackson. Mr. Kaiser, rebuttal.
Thank you, Your Honor. I want to touch on the preservation of my argument regarding Dr. Klingenpiel's testimony. In this case, trial counsel filed a motion in limine on this point well in advance of trial, which the trial court actually granted. And as this court knows, a motion in limine which is ruled upon preserves the issue for appeal and no further objection is required. So here, there was a motion in limine to preclude testimony going to the veracity of the victim. The trial court, in our view, incorrectly determined that the testimony that drew the objection did not violate that motion in limine. But it's our position that it did and that it was preserved in that ruling on that motion in limine.
Mr. Kaiser, aren't you trying to limit the inferences a jury can take from admissible evidence? If the evidence itself is admissible, what limits do we have to impose upon a jury on what kind of inferences they can draw from that admissible evidence?
Your Honor, I agree completely. Again, our problem is not with stating that a fact that 95% of sexual assault victims show no physical injuries. It's the next step she took beyond Pafford, beyond Keck, stating that the alleged victim's lack of physical injuries in this case was consistent with the overwhelming majority, and specifically that it was expected. So we have no problem, and this court has stated in those cases that statistics or that testimony that physical injuries do not occur frequently is admissible, and a jury would be allowed to make an inference from that mere fact. It's the fact here that Klingenpiel and the state went that step further in attempting to make that inference for the jury. That is what we are alleging was error in this case.
Did you ask for any limiting instructions to be given?
Your Honor, I don't believe trial counsel did.
What's your response to the argument that even if the court erred, there's no prejudice?
Yes, Your Honor. This is not a case of harmless error. This was a pure he said, she said case. In the case of Hopkins v. State, a 2017 Arkansas Supreme Court case, the court found that erroneous exclusion of evidence that went toward the alleged victim's bias was harmless error because it was a he said, she said case that relied entirely on the credibility of the various parties. So in a case without physical evidence and in a case that relies on a 14-year-old alleged victim as essentially the linchpin of the case, that this was harmless error is just not true. And it would be consistent with Hopkins that it was not.
How about the fact, though, that if you say it's not harmless error, it's still cumulative because you didn't object to Nurse Bradley's testimony, and she said the same thing that the doctor did.
Yes, Your Honor, except that Nurse Bradley did not go that step further in stating that the lack of physical findings was consistent with or expected based on this overwhelming majority of sexual assault victims who show no findings. Again, it's that extra step that Dr. Klingenpiel took that made this from arguably admissible testimony into completely inadmissible, irrelevant, and invading the province of the jury. A victim's fear of being killed or beaten up if he or she resists is insufficient to show forcible compulsion in the absence of evidence that a defendant ever threatened him or her before committing the sexual act. And I cite Mills v. State 270 Arc 141, a 1980 case. Subjective feelings of fear of physical injury by the victim must be based on some act of the defendant that can reasonably be interpreted to warrant such fear. And in this case, we just do not have it. JG's testimony was clear that she said nothing and did nothing. Her subjective feelings of fear of physical injury, while I have no position to comment on them, they were not based on any act of Barnum that could reasonably interpreted be interpreted to warrant such fear. And this case compares very favorably to the Mills case, where the defendant lured two juvenile boys from the Boone County Fair toward sexual trysts under false pretenses. And he even threatened violence against one of them in the aftermath, after driving him out to a remote area to have sex with him. And the Arkansas Supreme Court reversed and dismissed because those subjective feelings of fear, it found, were not based on some act of the accused that could reasonably be interpreted to warrant such fear. In this case, it pales in comparison to the allegations in that case, which were reversed and dismissed. I would just like to quote from the Holland v. State case cited by the state in their 5-1J notice to show how that case is very distinguishable from this case. In that case, AG, the alleged victim, testified that after she had made it clear to Holland that she did not want to have sex with him, he got on top of her and penetrated her with his penis. While Holland was in the process of this unwanted penetration, AG was crying and trying to squeeze her thighs together so he could not penetrate her any further. Holland continued even after AG was saying no and crying. From AG's testimony, the jury could reasonably conclude that Holland penetrated AG with his penis against her will while she attempted to physically resist him. And again, we just don't have any of those indicators of the victim's subjective feelings of fear that could reasonably be interpreted by Mr. Barnum to warrant such fear. This case is distinguishable. Again, we're not arguing that what happened here was good, moral, or even legal, just that it does not constitute the crime of forcible rape. In closing, there was insufficient evidence for Barnum's forcible rape conviction. The trial court abused its discretion by admitting several items of improper evidence, and the prosecutors made improper closing arguments. In addition to the other arguments raised in our briefs, Mr. Barnum's conviction must be reversed and dismissed, or alternatively reversed, remanded for retrial. I thank the court for its time.
Counsel, thank you all for your argument this morning. That will conclude this morning's oral argument. Our next argument will be held December 2nd via Zoom at 9 a.m. Ms. Clerk, if you'll close court. Thank you all very much.
Thank you all. Have a great day.
Thank you all.